Let me give you further updates in terms of what's just happened in the last couple of minutes. The prosecutor, Mr. Wyndham, says the defendant must not communicate about the facts of this case to any individual known to be a witness, except through counsel or in the presence of counsel. So, Andrew Weissmann, I'm going to ask you about that in just a moment. The judge then underscores that just a moment later. The judge then talks about the conditions of release and addresses Trump directly. The judge says to Trump at 4:26 p.m., "You have heard your conditions of release. It is important you comply to your conditions of release. You may be held pending trial in this case if you violate conditions of release." Now, again, that is the judge speaking directly to Donald Trump. And when she says you may be held, she's saying you may be imprisoned if you do not comply with the conditions of your release, which we are spelling out right here in court today at this arraignment. The judge then tells Trump, quote, well, I should not say it's a quote, as characterized by our reporter. The judge says the most important condition of release is that he not commit a crime while he is released. The judge says, quote, "It is a crime to try to influence a juror. Do you understand these warnings and consequences, sir?" Trump nods yes. He nods yes. Trump is also described as seated, a bit slouched, looking at the judge. The judge then presents to Trump a document, which is the written version of his conditions of release. Trump signs the paper. His defense counsel are described as looking intently on as he does so. Trump looks at the document he just signed. At this point, he is standing while swearing in the conditions of release. Again, Andrew Weissmann is there describing the conditions of release, and the judge is giving fairly stark warnings to Trump about violating the conditions of those release. That note that we have from the prosecutor, the defendant must not communicate about the facts of the case to any individual known to be a witness, except through counsel or in the presence of counsel. Does that map exactly to what he was told at his Florida arraignment, or is that differently phrased?
That maps with what the magistrate judge insisted on in Florida. The juror piece is not something that we heard in connection with the Florida case. I am not surprised by this, given the D.C. court. And remember, this is just, let's leave aside that this is the former president of the United States for a moment. We have a defendant who is charged with 2 separate types of obstruction in Florida. He is now charged with 4 types of obstruction here. What the judge overseeing this sees is somebody with 6 types of obstruction of justice, and is saying, if you are going to talk to a witness, it's got to be in the presence of counsel. If you are going to communicate in any way with a juror or try to interfere with a juror, that is a crime. Not at all surprising. Remember, this is the courthouse where Paul Manafort violated that condition and went to jail. It's a courthouse where Roger Stone threatened a federal judge and posted a picture of her with crosshairs next to her, leading to severe sanctions and restrictions on his ability to communicate. So it's not surprising to me if you just treat him like anyone else, it's that you have that much obstruction and you're going to have these kinds of warnings being given to the defendant. Let
me just underscore what Andrew is saying here. The judge, again, per our reporters who are at the courthouse, tells Trump, "You have heard the conditions of release. It is important you comply to your conditions of release. You may be held pending trial in this case if you violate the conditions of your release." The judge then says to him, the most important condition of release is that you not commit a crime while you are released. And then the judge says 2 minutes later, it is a crime to try to influence a juror. And while that is obviously true and something that, those of us whose only legal experience is watching TV, to have that the former president bluntly warned of that in the courtroom today while he is being threatened with jail if he doesn't comply with it, is a stark thing.
I just want to make a point, and Andrew can back me up here. Admonishments, I think, are normal.
Sure.
Don't tamper with the jury, unless I'm wrong, is not a standard thing that a judge says to everyone walking in and out of a federal courthouse for arraignment. Like, that strikes me as a very Trump-specific admonishment. And
well,
a very
every judge has their own boilerplate, right, in terms of what they do. I don't know what this magistrate judge does in every proceeding.
I don't know either.
Yeah.
I just think it's possible. I would just leave open the possibility that this magistrate judge's boilerplate isn't "don't tamper with a jury." I mean, I really don't think that's Andrew, you've appeared in these arraignments, and I'm curious what you think.
Yeah, so two things stood out to me as unusual. It is not unusual for the magistrate judge to have talked to the assigned district judge to find out what the next date is. What is unusual is that, to your point, Chris, to be so focused on the trial date and to have obviously from the district judge the dates by which she wants submissions on that issue, and it's going to be decided on the 28th. That, to me, is for people who are thinking that she is not focused on whether this can go to trial before the general election. That is the issue. And it is also clear that John Lauro knows that, and that is the reason he started saying, I need to know about the volume of discovery, because it's going to be a little eye-popping. There is going to be a huge amount, and the government's going to have to deal with that issue, but that's going to be the fight. The second thing is to Chris's point about usually the standard condition that a judge emphasizes. And I thought when I heard it was going to be, and she reiterated, the most important thing is, I thought it was going to be that you have to show up at each court appearance. That is the most important thing. That is what bail is for, is that you will show up in court. When I heard that the standard condition and the most important thing is do not commit a crime, followed up by do not tamper with a juror, my reaction was, I was a prosecutor for 21 years. I was a defense lawyer for 5 years. I have never heard
Fair
that.
enough. Wow. I stand corrected. Absolutely.
I want to, in a quick follow-up, what did feel unusual to me, too, given the fact that Donald Trump has a history of attacking Jack Smith personally, attacking his wife, and that people around him, like Roger Stone, have histories of attacking the judge. This judge would single out the jury and not talk about not making inflammatory comments about the prosecutor, because that is something Trump has done.
Well, also remember, before any criminal case, Judge Kaplan, overseeing the E. Jean Carroll case, on his own took steps to protect the jury in that case and give admonitions in a civil case, with respect to the former president of the United States taking steps to interfere with the jury in that civil case. So it's not surprising, given that, and given, just remember, any other defendant who is facing obstruction of justice charges in this many cases, this is not a surprising development, other than if you suddenly are thinking about the fact that what his former position was, that he was the former president. But if you want to treat him the way anybody else would, this is what you do.